SJC-12409, Carmen Correa v. Andreas P. Schoeck, and others.
Mr. Green, good morning.
Good morning, Mr. Chief Justice and associate members of the court. My name is Tom Green, and I represent Carmen Correa, the appellant here, and with me today is Mr. Tabb and Simon Fisher. I'd like to start with the argument that Walgreens has a common law duty to notify the prescribing physician.
Would they have that duty even if they had not implemented a policy to do so?
Yes, they would.
Okay, can you explain the basis of that for me?
Yes, I would. In determining whether a duty exists, this court has said on many occasions that you first turn to social policy, custom, and social values. And we know from the briefs before the court that insurers use prior authorization to ensure that a prescription or medical treatment is medically necessary and appropriate for the patient. It's used by insurers to help control healthcare costs, and it's also used by insurers to prevent waste. These are all important social policies that this court considers in determining whether a duty exists. But there's a more important social policy at stake in this case, and that is that when there's a restriction that prevents a patient from getting the medical treatment their physician has recommended or prescribed, especially those members of our society who are most vulnerable, then there should be a duty recognized here that a pharmacy can convey a simple notice to a physician of the prior authorization restriction, which will allow the patient to get the prescription drug, in this case, that the physician has prescribed. That's an important social policy.
Procedurally, the physician writes the prescription. Why isn't that the authorization needed by the insurer? I'm just trying to understand.
The practice, Your Honor, is the physician writes the prescription. It can be a written prescription, or sometimes it can be electronically transmitted to the pharmacy. It's presented at the pharmacy, and the pharmacy is in the position. The pharmacy is a healthcare provider, and they're in the position then where they're going to process the claim. They're going to submit it to the insurer, and they do this electronically. And instantaneously on the screen, in response to the submission, the insurer may have a prior authorization restriction in place that pops up on the screen. And then on Walgreens' screen, there's a fax icon that pops up, and that can be pressed, which will send a fax to the prescribing physician with the patient's name, the prescription, the dose, the date of birth, the insurer contact information. And that's the information that Dr. Schoeck's office takes, that prescribers take, and they fill out a prior authorization form from that insurer. It's signed, there's some diagnosis that's entered by the physician, and then it's sent into the insurer. That's the way the business is set up. The pharmacy here has an economic interest in seeing this goes through as quickly as possible, because they're not going to get paid unless it does go through.
I guess I want to go where Justice Cipher was. So maybe we'll get to whether they assumed a duty. But when you take a pharmacy, they have no control over the prior authorization, they have no control over the doctor, and they have no control over the health provider, and they're going to have a common law duty of care?
Yeah, I'm not sure that's quite accurate. This is the way I would describe it. When the prior authorization restriction is sent to the pharmacy, it's only sent to the pharmacy. It's not sent to the patient, and it's not sent to the physician. That's the way the system is set up. They have to do something with that information. They can't do nothing. They recognize it. They've they've automated their computer to send notice to the physician. They've trained their employees to call the physician and to fax notice for the physician.
They tell their customer, you need to contact your insurance provider, right?
They tell the patient, who is their customer, they are recognized.
That's what happened in this case. On multiple occasions, they said, well, you need to talk to your insurance company.
They tell they tell the patient two things. And we don't want to lose sight of the two things they tell them. They tell the patient, we're going to contact the physician. And in this case, there's evidence on one of the first conversations they had. This happened on at least 7 occasions over a period of several months. They have computers that notify them when prior authorization pops up. They told that to the
Yeah,
to the
I know that
patient.
there's an icon, and that was your for want of argument.
Right. But they also say, and you should call your physician as well to let him know prior authorization is required. So they tell them those two things.
But the duty you are asking us to impose is not a duty to obtain the authorization. It is a duty to request the authorization.
That's correct, Mr. Chief Justice. It's a very narrow duty here. The professional parties here are 3 parties: the insurer, the pharmacy, and the physician.
Maybe I'm missing that. I thought the duty was to notify the physician, not to request.
I think that's the question I just heard from the Chief Justice. Maybe I misheard it, but I think what I heard is you're asking the duty here you're seeking is a duty to notify the prescriber that there's a prior restriction.
Big difference between send a notification and notify. Unfortunately, the way things work in the world, those are 2 different things. And I imagine perhaps in this situation, we saw that play out. We don't know. I'm not saying that that's this factual record, but send a notification and notify are 2 different things. And it may well be in this situation that notifications were sent. I understand on the deposition, no one could say for sure, but it may be that notifications were sent, but they didn't notify.
Well, I think now what you're talking about, and you correct me if I'm misunderstanding you, but you're really talking about the scope of the duty. And if you're talking about the scope of the duty, the form the notification is going to take and who it's going to be given to, implicit in that is recognition that a duty exists.
Exactly. You're not saying it's enough to hit the icon with the mouse.
Pardon me?
You're not saying it's enough to hit the button.
No, I'm saying you've got to send. You have to send the notice. And what we have
You're
here.
saying that's not enough. I mean, you're not saying just go in there in the pharmacy, you go on the computer screen, you hit the notice to the doctor's office, and that's the entire duty. I think you're looking for more than that. Tell me if I'm wrong.
Well, and if the prior authorization restriction is not removed, then there's got to be some follow-up, and they train their physicians to follow up.
So I want to make sure I understand your response just slowly. So it's not enough for them to send out a notice, meaning either a fax or a telephone call or an email. They have to actually get a response back?
Well, here there's
'Cause that seems,
there's evidence in
that's a big difference, isn't it?
well, there's evidence in the record here that they experienced failed fax notifications. And they have no way of determining whether the fax went through or not. It's different today, but back at the time in 2009, they weren't able to determine that. So there has to be some follow-up. And when the family came back in again.
But that's difficult, right? I mean, all of us have tried to get a hold of our doctors. It's one thing if we have to send a notice, if the pharmacy has to send a notice, and it's another thing if they actually have to get a hold of the doctor's assistant and have a conversation. That's a whole different story, isn't it?
Well, no, it isn't. It's their customary practice. It was Walgreens' practice, and it's the practice in the industry. There's testimony in the record that Dr. Schoeck's office routinely received prior authorization fax notices from Walgreens, but they also received them from CVS and Rite Aid. So that customary practice works in favor of recognizing a duty here, a duty to communicate to the prescribing physician that prior authorization is required.
And what should they do at that point? Suppose there was a record that Walgreens, they had actually made that fax, sent that fax 7 times. Would they still have a duty to do anything further?
Yes, we have presented the expert testimony of Dr. Aldrich. And Dr. Aldrich is prepared to testify that the standard of care here requires the pharmacy to notify the prescribing physician of the need for prior authorization. And if that isn't acted on, then the pharmacy has a duty to make repeated and more emphatic contacts.
So it becomes the duty of the pharmacy is a duty that is dependent on the quality control of the physician's office.
Well, I wouldn't say, you may say the quality control of the physician's office. The facts in the record are that the fax notices come through, and the protocol within the office was to pick up the fax, to complete the prior authorization form, depending upon the insurer, to put that form together with a patient's chart on the physician's desk, and then he'd complete the remainder of the form and submit it.
But then aren't you converting the physician's duty into the pharmacy's duty? I mean, I understood you when you were saying, you know, they have this information that the doctor doesn't yet have, but they can't make the doctor run an efficient operation. All they can, I mean, and they can't, they've got a job to do themselves. I'm worried about also when it's not Walgreens, but some local pharmacist who's working by him or herself in a smaller operation without all this computer support. I take it the duty's the same, right?
It would be the same, and our contention is not that they have a duty to ensure that the doctor acts on the notice.
How do you define
But
the
how would it
duty is?
end?
What is your duty then? Your duty is to what to the doctor? Get the doctor to answer your calls, or what?
The duty is to transmit notification that there's a prior authorization restriction that's preventing the prescription from going through.
Can I ask
That duty, excuse me for one moment, that duty could take the form of the fax followed up by phone call.
I'm sorry, Just Cipher, did you have that?
No. I would just wanted to know actually how far it would go.
Okay.
How many times do you have to notify the doctor? You say until they respond to you.
Well, Dr. Aldridge, our expert, says that, you know, more emphatic steps were needed, certainly by the third time. Remember, the script was submitted on September 8th. It was restricted the 18th and the 28th. At some point, Dr. Aldridge says the pharmacy had a duty to speak personally to the physician to let him know that the prescription couldn't go through. Keep in mind that this was an anti-seizure medication. She had been without it since August 26th. She suffered a seizure on September 2nd, the fatal seizure at the end of the month. The pharmacy was the only one that knew that prior authorization was required. Schoeck's office did not know that and would not know that unless he was informed by the pharmacy and by the patient. The patient's family here did exactly what they were instructed to do. They relied on what the pharmacy said. The pharmacy said...
And I want to ask you about that point, because I want you to pivot to the assumption of a duty. Here, the defendants argue that the duty of a pharmacy is simply to fill the prescription properly, to give the right dosages, et cetera. But in this case, it could be argued that the pharmacy said, we'll take care of this, essentially, and that the patient then said, I don't need to talk to my physician because the pharmacy is going to send the notification. Is that an assumption of duty by the pharmacy, where if they didn't have one, now they do?
Well, that was our second argument,
And
and
that's what
I'd
I
like
want
to
you-
address
yeah.
that now. Voluntary assumption of the duty. And this court in Cottam recognized that a pharmacy could voluntarily assume the duty, and that's what we have in this case. They said that we will notify Dr. Schoeck that prior authorization is blocking the prescription. And they did that not just on one occasion, but they did it on 7 occasions. And during that period of time, every day that passed, that Yurishka Rivera was without a prescription, she was at risk suffering a serious injury and potentially death. And that duty, and Dr. Aldridge addresses that, as the time passes and she remains unprotected, suffering a seizure on September 2nd, the duty to exercise care is heightened because the risk of harm is increasing here the longer she's without her anti-seizure medication.
So the argument is that the patient is going to forego the notification because the patient reasonably thinks that the pharmacy is going to take care of it.
Well, yes. Under the restatement, we have to show that her reliance on their undertaking increased the risk of harm, which it did over time. She and her family continued to return to the pharmacy, which is evidence of their reliance. And also, she relied on that. She was induced to forego other opportunities. We made that point in the brief. She could have brought the prescription to another pharmacy. If she had been told by the pharmacy, look, we might get too busy here. There's testimony in the record that one pharmacist is filling more than 100 prescriptions during his shift. If he were to say, look, we get very busy filling other customers' prescriptions, and we may not get to call Dr. Schoeck, or we may forget, or we might not follow up on the next shift. Or had he said, look, we have fax failure notifications that occur here. Sometimes the fax doesn't go through, and we don't know if that happens. Then they would have brought the prescription to another pharmacy. So there was reliance there in that regard.
Am I correct that the request for prior authorization, or the need for prior authorization derived from the fact that this was a brand-name drug and not a generic?
No, prior authorization requirement is imposed by insurers. Sometimes they want to see, this was a brand name drug. Sometimes they want to inquire about that and whether a generic, because it's less expensive, would be appropriate for the patient. What happened in this case, Your Honor, is that once she turned 19, Mass Health had a regulation in place that required physicians to get prior authorization.
For all drugs or only for certain drugs?
This was for Topamax. I'm
That
not sure
particular
about.
drug.
I'm not sure about all drugs, Your Honor.
But I mean, but in a broader sense, somebody seeks a brand-name drug, needs prior authorization, you would notify the doctor potentially could say, I'll give the generic, and could then issue a new prescription to the pharmacy, which you could then issue without prior authorization.
That's correct. That could happen.
So, just to be as precise as we can, apart from the assumption of duty, which we'll put aside for a moment, I want to make sure that we understand, because there's been some discussion here, as to what precisely you say is the duty of a physician. Is it the duty of a pharmacist, the duty to make reasonable efforts to notify a doctor of the need for prior authorization, or is it more than that?
I think there's a second part to that. If the doctor doesn't act on the notification, to take some further step to notify the physician. And Dr. Aldrich says that in his opinion, which we have attached, that once it became clear to the pharmacy that the prior authorization restriction remained in place, and I believe he said that would be after the second or third attempt, so September 18th or 28th, the pharmacy had to do something more. They had to have personal contact with the physician to notify him that the prescription couldn't be filled.
Would that be true even if there was no specific risk to the patient, such as the seizure? So for any kind of prior authorization?
Would what be true, Your Honor?
What you just said, they would have a duty to make contact with the physician's office. Is that so even if they are not aware of a specific harm to the patient from not obtaining the medication?
If I'm understanding your question correctly, I would say that communicating the notice of the prior authorization and following up if it's not acted upon within a reasonable period of time would apply to all prescription drugs because there is no burden. There's very minimal burden here. The computers are automated to send that notice. The employees are trained to deliver that notice. It's part of the process of filling the prescription that pharmacists engage in those type of activities on a daily basis.
That's again confusing. Send the notification with what the chief is trying to get from you, which is what is the notification responsibility? Okay,
let me try it again. Just to press the button and say you have sent the fax. When sometimes the fax fail, that would not be sufficient. There has to be some follow-up within a reasonable period of time.
They follow up. I mean, you would want to ensure that the communication was actually received in some fashion.
Yes, and the follow-up could take the form of a telephone call. And at some point, our expert has said that the follow-up has to be more than that. It has to be a communication directly with the prescriber. And maybe this is coming back in response to your case with regard to this particular medication. to let his patient know that the patient is at risk of severe harm or injury.
That is my question, because you do make the point, don't you, in your brief, that in this particular case was a unique situation, and there was a special duty on the pharmacist because they knew she was at risk.
Well, that's our third argument, and if I could turn to that for just a moment, you're correct, and you recognized this factual scenario in Cottam, but now you have the facts before you where you can decide whether a duty should be imposed in this situation where the pharmacist had specific knowledge of a potential injury to his client. Remember now, I'm going to repeat it again, the pharmacist knew that Dr. Schoeck was the only one that could provide the prior authorization. Only the pharmacy was notified of the need for prior authorization, and the pharmacy knew that she was without her anti-seizure medication, and that she was without her anti-seizure medication for week after week after week. And that special knowledge, only the pharmacy had. Dr. Schoeck didn't have it.
But the pharmacy's not privy to all the information between the patient and the doctor. In fact, none of it. I mean, is this rule going to apply in opiate cases too? I'm just trying to understand because, you know, there may be a whole bunch of reasons why the doctors aren't getting back to the pharmacists.
So I think one of the basic premises on the learned intermediate doctrine, and when it was applied to pharmacies, was the same with regard to drug manufacturers, and that was that the physician has knowledge about the patient's condition and medical treatment and the reason for the prescription. But here, this is really outside the application of the learned intermediary doctrine.
I'm not sure it is yet, because it was when, if you had answered the chief's question, yes, or the earlier questions, but you're requiring sort of a direct communication with the prescriber. It's not enough to call, I take it even under your rule, it's not enough to call the office of the doctor and say, we haven't gotten this. And the person says, yep, okay, thank you, and hangs up. That's not enough, right?
Okay, I think we're arguing that there's a duty here, and there are three ways to recognize a duty, that a duty should be imposed.
Well, we're trying to define the duty, and not just in the factual circumstances of your case, but you're creating this broad-based duty for pharmacists in almost unlimited circumstances to notify physicians about prior authorization. And I'm just worried about opiates and other kinds of drugs where there are all kinds of reasons why they may not be getting back to you.
I think the duty that you could find, the court could find, is that it is a limited duty, that when a pharmacy knows of a prior authorization restriction that's preventing the patient from getting the medication, that they should notify the physician, and within a reasonable period of time, if there's no action, they'll need to follow up on that to speak directly.
How do you decide what a reasonable amount of time is?
Well, we did here in this case with an expert opinion. And you could also decide it.
So would a pharmacy have to have an expert handy to help guide them when they should keep going?
Well, they do certainly have some expertise. They're not just, filling prescriptions. Right. They know something about the medications, the warnings, and the contraindications. But we're not asking that the court recognize a duty that the pharmacist has to warn of side effects or contraindications. What we're talking about is particular knowledge that the pharmacy has that the prescribing doctor doesn't.
What you're looking for, can that be analogized to any other situation with a healthcare provider? You're looking for a specific duty. Can you think of any other things that we can look at to say, oh yeah, this is sort of like that?
Well, the court in Cottam pointed to some cases in other jurisdictions where the pharmacist had special knowledge of a particular danger to the patient.
So that's your third argument?
Yes, correct.
But for the first argument, pharmacists have a duty.
Has a common law duty to notify the physician, again, for this narrow duty when a prior authorization is preventing access to the prescription. I'm not thinking of another factual. I don't see. We searched high and low, and we could not find another case and I don't believe Walgreens did either, around the country where this liability arose for failure to notify regarding prior authorization. And one of the reasons I think that is so is because the industry does it as a matter of practice, and it just doesn't happen. It's not going to unleash the floodgates for litigation, as Walgreens argues in their brief. It hasn't happened.
Now, one thing which you've not mentioned within the duty is a duty to provide emergency medication in the interim. Is there no such duty here, given that?
Thank you.
That Mass Health will pay for 3 days?
Thank you for pointing that out. It was an argument we raised in our brief. Walgreens never offered to the family that they could provide a 72-hour supply of medication, and that would have been paid for.
I thought they did that the first time.
No, they did not. And that would have been paid for by Mass Health.
So they
And
never.
that's not just a one-time offer. That could have been offered repeatedly.
But is that within the scope of your duty, or is that outside the scope of your duty? I don't know that you referenced it in your brief.
No, we didn't. You are correct. We referenced it, but not as part of the scope of the duty. We referenced it.
Sort of need to ask us whether or not that's part of the duty here, because we're going to be arguably defining that duty. Do we exclude that? Do we include that?
I think it makes sense to include that. I think it makes it, especially in the factual circumstances before the court in this case, in the period of time that this went on, over 6 weeks, 8 weeks they had notice. They had notice, Walgreens had notice from June that the prescription would not be filled without prior authorization once Yurushka turned 19 on August 3rd. They brought that to the attention of the family mid-June, again in July, in a conversation in August, and then on all 5 occasions that they presented the script to be filled. So I would ask that you find that be part of the duty. Certainly, maybe it's limited to the facts of the case. As Justice Seifer said, the medication, this anti-seizure medication, if a patient doesn't get that and suffers a seizure, they could suffer serious injury, potentially death. I think recognizing the duty to offer the 72-hour supply would be appropriate on these facts.
Okay, thank you.
Thank you.
Mr. Murray, we appreciate your patience.
Thank you, Your Honors. Good morning, Chief Justice and Your Honors. May it please the court, my name is Bruce Murray, and I represent the defendant, Walgreens, in this case. I suggest that imposing a duty on a pharmacist to notify a prescribing physician when payment for prescription medication is denied by a customer's health insurance would be an unwarranted and ill-advised expansion of tort law, which doesn't exist anywhere else. Prescription drugs and the practice of pharmacy are heavily regulated at both the state and the federal level. They're regulated in Massachusetts by the Board of Pharmacy. They're regulated by the FDA and other agencies as well. Yet despite all of the regulatory provisions which govern the practice of pharmacy, as well as all of the case law throughout the country in which pharmacists have been sued for various reasons, there is no authority from any single source which in any way imposes a duty on a pharmacist to notify
Is
the prescribing.
this pre-authorization, I take it this is out of the cost control initiatives of.
Pre-authorization, as I understand it, is imposed by most insurance companies. It's a effort to reduce costs. It's a way to get doctors, or I should say it's a way for them to be able to supply prescription medication to patients at a lower cost. For instance, some medications, there are many medications that might treat the same.
My first question is, how novel is this? Is this, like you say, there's never been imposed, and I'm just wondering if this, because pre-authorization is not getting the prescription, it's basically a step before getting the prescription, right? And I'm just trying to understand, is this a recent development?
No.
And therefore, might explain why we don't have any cases on this.
I believe not, and I can't quote the exact year, but I believe it was in one of the amicus briefs that was filed, I think either by the Health Law Institute or the other, where they had provided some information as to for how long the prior authorization had been around. In my understanding, it's been around for decades.
So I'm trying to figure out why you say it's ill-advised, apart from the fact that it's outside the scope of the existing regulations. If I go to Walgreens with a prescription, I gather one of the first things they're going to do is they're going to see whether or not my insurance will pay for it, correct?
It's not actually the first step, but yes, it's part of the process.
Okay, it's before they come to me and say, this is what it will cost, because they need to know how much to charge me.
Correct.
And if they say this requires a doctor's authorization and you don't have it, I gather they will routinely then notify the doctor that in order for this to be paid for, and it could be hundreds of dollars, as this was, I think the cost of this was $399 in the absence of authorization, they would then go to the doctor and seek authorization, because they want to get paid for it.
I would not say that they routinely do that. I mean, we're talking about the pharmacy industry in general, that when there's a problem with a prescription, for instance, involving payment, they notify the customer. They let the customer know that it's been denied, and they tell them the reason why it's been denied, and they instruct them that they should contact their physician. I mean, the problem when a prescription is not paid for by insurance, it's not because of the pharmacy. It's either because the doctor prescribed a medication that requires prior authorization, where there could have been an alternative, or it's because the insurer doesn't pay for a medication without prior authorization, or it could be because the patient is either unwilling or unable to pay for the medication. But none of those factors are because of anything that the pharmacy did. They don't have any role in that because they can't request authorization, they can't grant authorization, and they can't ensure that the patient exercises the responsibility that they have to ensure their own good health and
But they
good
have
medical
a
treatment.
piece of information that the doctor doesn't have, which is that the patient isn't going to get the medicine unless this form is filled out. They're sort of they're a necessary link in this whole process for the, right? And they're the ones who have the most information. That's where I worry that to say they have no duty whatsoever, I can understand a limited duty, but
Well, they
no
don't
duty.
have the most information. They have the same information that is
The patient.
imparted to the patient. And one of the bedrock principles of tort law is that a person does not have a duty to another to prevent harmful consequences for a condition that they don't
But you're not a
create.
bystander, right? You're different from a bystander. You do have a duty to the patient to give them the right medicine, right?
You have a duty to give them the right medicine.
You're
You have a
not like
duty-
someone on the street, right?
You have a duty to, right, but that's the narrow scope of the duty, is to fill a valid prescription, if it complies with what a prescription is supposed to say. They have to follow the directions. They can't deviate from what the prescription says in any way. And in some circumstances, they might have to impart information to the patient. But that's the limited role. They're not a conduit between the doctor and the patient, or the patient and the insurance
But
company.
what about the
over issues.
voluntary assumption, Mr. Murray, of the duty, where they can tell the customer certainly, and they did in this case, you need to contact your physician because you need prior authorization, but then they also say, we're going to call the physician's office essentially so that you can get the medicine, and the customer could reasonably say, well, I don't have to do it because they're going to do it and forego their direct contact. So hasn't there been an involuntary assumption of a duty, especially in a case where there's this anti-seizure medicine or something that could lead to some harmful results?
I would say in this case, not, because in order to have there be a voluntary assumption of duty, there's a number. It's not just because they're aware of some harmful consequence. in order to be held liable under the voluntary assumption of duty, first of all, they have to recognize it as necessary for the protection of the person. And then it's one of an alternative of two additional prongs. Their failure to exercise care has to either increase the harm or the harm has to be suffered because of the other reliance. Now, with respect to prescription medications, the mere fact that a patient presents a medication, a prescription to a pharmacy does not automatically impart on the pharmacy specific knowledge as to what the medicine is being used for.
Even anti-seizure medicine?
No, especially in many medications, including Topamax, can be used for multiple purposes. For instance, Topamax, according to the record, is FDA approved for seizure, but it's also approved for the treatment of migraines. She was also taking
So off-label takes them out of liability?
medication. There are sometimes that doctors do prescribe it, but when assessing whether or not a pharmacist has the ability to recognize as necessary for the protection, many medicines can be used for multiple purposes, and a pharmacist certainly doesn't always know the reason for that. For the same reasons why this court and other courts have said that pharmacists don't have a general duty to warn. Pharmacists don't have the requisite medical training, they don't have the education, they don't have the unique background and history, and the mere fact that somebody presents a medicine that may treat some particular condition is not, I would suggest, sufficient to impart on them the information that they should recognize as necessary for the protection
But the
for the
problem
customer.
is, that's all true, and we have a system in place. Maybe it's not the right system. Maybe the right system is that the doctor has to be vigilant, and the patient has to be vigilant and persistent, and indefatigable to make sure that they get what they need to get and that they prescribe what needs to be prescribed. But that's not the system. The entity that has the information is the pharmacy. So if they're the ones with the information, do they at least have a duty to forward the prior authorization to the physician?
To avoid?
To forward it, to send it?
No, I don't. Because I think there are many circumstances where one party may have information. For instance, cases involving duty to warn, whether it's premises liability, pharmacy cases, medical malpractice cases, all of those cases say that there's a duty to warn the consumer or to warn the patient or to warn the person on somebody's property. To the extent that there is any duty whatsoever, notifying the patient what the reason, what the problem is, and what they have to do to correct it would satisfy whatever limited duty there is. This is not a situation, for instance, where the customer comes in, it's been denied for prior authorization, and the pharmacist says, I'm sorry, it's not ready. And then they come back again and say, I'm sorry, it's still not ready, and come back, and that repeats. Each time they came in this case, they were informed exactly what was wrong and exactly what they had to do. Further, in this case, the evidence, the uncontested evidence, is that the customer told Walgreens that we will notify their doctor. And I believe they told them on at least 2 occasions that they had notified the doctor and that we would again notify the doctor. And I think Walgreens would certainly be justified in relying on that information that the doctor had in fact been informed. Simply because prior authorization hadn't been granted, and I believe one of your honors brought this up previously, doesn't necessarily impart knowledge that it wasn't because the doctor didn't know, particularly in this case where the customers have said that they have notified the doctor. There are many reasons why. All the pharmacist gets is a rejection, and it says that it's rejected for prior authorization or for a number of other reasons. But
Now,
that's the only
before we had all the computer systems in this circumstance, theoretically, the pharmacist could hand the prescription back to the patient. Sorry, this has not been authorized previously and it requires it, then the patient would take their prescription and know they now have custody of it. Nobody else is going to do anything with it. But with the computer system and the fax button, doesn't that change the relationship a little bit?
I don't think it does, because, first of all, it's not a situation that they've created, and it's not a situation over which they don't have the ability to control the doctor, and they don't have the ability to control the insurer, and they don't have the ability to control the patient. The patient could certainly ask for the prescription back, but it wouldn't matter in this case. They could bring it to any pharmacy, and it's still going to require prior authorization. It doesn't matter whether the pharmacy has a computer system or doesn't. They're still going to be faced with the same problem that they're faced with no matter what, and she's still going to be exposed to the same danger, and that being that she may have another seizure.
But the difference is that when a doctor prescribes medication, especially medication of this type, transmits it to the pharmacist, for all practical purposes, the absence of prior authorization means that the doctor's prescription is not being effectuated. It's not being given to the patient.
That's true.
Doesn't the pharmacist have some obligation essentially to tell the doctor that although you've given me a prescription to give this medication to your patient, I cannot pragmatically do so because you have not given me prior authorization from the insurance company?
No, I don't believe they do, and I think that sort of goes back to what is one of the bedrocks. They don't have a duty to intervene on behalf of somebody for a situation which they neither created or which they created. The situation wasn't created by Walgreens.
But the very essence of a pharmacist is the doctor can't give the patient the prescription. The doctor needs the intermediary of a pharmacy in order to do that, and the doctor has given you a prescription saying, I prescribe this for my patient, and you haven't given the patient that medication. Does not impose some obligation on you to say, doctor, I have not done what you've asked me to do because you need to do one more step?
No, and here's the reason why, and that's because it's not that the patient can't get the medication. The reason they can't get the medication is twofold. One, that the insurer won't pay for it, which is something beyond the control of the pharmacist, and the patient is either unable or unwilling to be able to pay for it, which is also beyond the control of the pharmacist. And it would be unfair to impose a duty on a pharmacist which really has no right and no control and is not even the cause of the problem, to now have to intervene and start to advocate either with the doctor or the insurer when they have no right and no responsibility to do so.
The problem is there's no right, there's no control, but you're the nerve center of the system and the information and the conduit. So if the pharmacist is not notifying the system, whether the system is broken or not, put aside, the system doesn't work without the pharmacist having to be a quarterback.
Well, the pharmacist tells the patient. Now it's the patient's responsibility to notify their doctor or do whatever else is necessary in order to make sure that they get the medical care that they require.
And that's a fair point, but I mean, to sort of be blunt about it, if that happens to some people, they'll just sit outside the doctor's office and wait until the doctor comes out and says, I want my anti-seizure medication or I'm going to die. But some people don't have the wherewithal for many understandable reasons to do that, and then you have a pharmacy and a pharmacist who's saying, I'm going to take care of this. I'll contact the doctor. And is there at some level, I guess this is back to the Chief's question, is there some level of responsibility there since the system has you as the epicenter of the information?
Well, but see, the information that has to be communicated to the patient, I mean, this isn't complicated or highly technical information, and it's no different than any other duty to warn a general consumer. The information is simple. The person doesn't have to have super intelligence or any technical knowledge about insurance or medicine or the practice of medicine. What they need to know is that my insurance company won't pay for it, and my doctor has to do something to take care of it. That's a very simple message, and any person of average intelligence or low intelligence should certainly be able to understand that.
So there is a duty, but it's just to inform the patient that they need to get authorization. It's not that there's no duty, right? There is a duty under your view then.
I mean, I would think, common sense would say that there has to be, that the patient has to certainly at least be informed.
Right, so, but I guess, so the duty, you fulfill your duty when you inform the patient. You have no duty to do any additional steps.
Exactly.
Now, it's somewhat perplexing to me that you're saying it would be fundamentally unfair to impose a duty to ask Walgreens to do what Walgreens, as a matter of custom, always does. You do it all the time.
Walgreens
It's a
does,
matter of
well,
corporate practice.
Walgreens does it, but we're talking about imposing a global duty on all pharmacists. Now, Walgreens, obviously, they're a large corporation and they have sophisticated systems. But as I believe Judge Kafka mentioned, this duty is going to impose this, if the court imposes the duty, it will be imposed on all pharmacists. It will be imposed on Theater Pharmacy in Lexington Center or Brattle Pharmacy in Arlington, who may or may not have these types of computer systems, who may or may not have the resources that a large CVS or a Walgreens might have. Yet you're still going to be subjecting them to litigation, which would...
Well, you'd be subjecting them to a telephone call, then, if they don't have a computer system to do it.
Once the duty is imposed, now it opens up, I suggest, it does open up a significant increase in potential litigation against pharmacists. Pharmacists, in order to shield themselves from liability, are now going to have to document every rejection, every communication, every attempted communication. The court is now going to have to assess what extent what knowledge did the pharmacist have? Was this a anti-seizure medicine, or was this an anti-itch cream?
Okay, but even under your view, you still need to document the fact that you inform the patient that you need authorization, correct?
In this case, there isn't any documentation that they informed the patient.
Okay, but in your world of unfair burden, the need to document it, to cover yourselves, wouldn't be also imposed if you have to tell the patient? And would you also have to tell the patient the precise name of the medication, especially if it's hydrochlorothiazide, or words which you say are simple, but medications may have very complicated names, especially when they're generic, and the names may matter in terms of how precise the request is to the doctor.
No, well, I don't think they do, because when the patient goes to say, I'm here to pick up my, whatever, the prescription I dropped off yesterday.
That assumes that it has not, most doctors would directly transmit that to the, or many doctors will transmit that electronically to the pharmacy, and the patient may not even remember precisely what has been prescribed.
No, they may not, but I think that most people, when they're coming to the pharmacy to pick up their prescription, they certainly have some idea about what they're going to get. So in terms of telling them that the prescription that you came to get.
We have people who are poor, people who may not speak English very well, people who are elderly, and we're going to count on them to be accurate correspondence of the particular prescription that they want the doctor.
Right, because I don't think that poor people or elderly people have any less intelligence than
It's not a matter of
wealthy
intelligence,
people
it's a matter of precision,
young
isn't it?
people.
Isn't it a matter of precision and prior authorization? That's going to be understood precisely as to what that means. Prior authorization, the doctor already authorized it. So what you're asking them to do is you need the doctor to obtain the insurance company's authorization. It's not as simple as it may seem to you.
Well, respectfully, Your Honor, and I would disagree in that I don't think that the precision as far as all the mechanisms that need to be in place. It's no different than telling a patient, for instance, that you can't take these two medications together because it might stop your heart. They don't need to know about all the chemical reactions and the metabolic processes that go that are involved as to why. They need to know that I can't take these two medicines together because they're bad for me. Likewise, in this case, they don't need to know all the mechanisms about how authorization, what forms need to be submitted, what information needs to be put on, what the process is for the doctor. What they need to know is my prescription can't be paid for, not that it can't be filled, my prescription can't be paid for by my insurance until my doctor takes some affirmative step to make a request. And that's a very simple concept that almost anybody can understand, and being told that that's what you need to do. Tell your doctor, let him know that the prescription that he prescribed requires prior authorization is really all the information that the patient needs to know and what they need to impart onto the prescriber.
Does Mass Health have some kind of obligation to communicate this pre-authorization protocol? Do they have a duty?
Perhaps they do. I don't know the answer to that, but in going back to what I said earlier, there's 4 parties involved here. 3 of them have some ability to do something to cure this problem. The doctor can do something about it, Mass Health can do something about it, and the patient can do something about it. They're the only ones that have the authority and the control to make the prior authorization go forward. The pharmacist, who has the least ability to, they don't have any ability to authorize or control, yet the appellants want to impose the duty on the pharmacist. You know, why shouldn't the duty be imposed on Mass Health, for instance?
Well, because the system in place, for better or worse, is that the pharmacist is the conduit.
The system in place at, well, in fact, the testimony, and if you're honest, read the testimony, is that all of them say that the policy is that we notify the patient. That's what we do each time, that's what we do every time, and that's what they did each time and every time that the patient did here. They also went on to say that sometimes, as a courtesy, we will say that we will notify them as well, but you need to tell your doctor. And in fact, that's what the Rivera family had testified to. It's in the record appendix at page 70, where they go, and these were actually answers to interrogatories. And they mentioned that repeatedly when they would go to the pharmacy, they were told that it needed prior authorization, that your doctor needed to fill out a form, and that you need to inform your doctor. And they responded more than once that they would, and they told the pharmacist more than once that they in fact had. I mean, Walgreens certainly had no reason to know that that the doctor had not been informed. They certainly had a right to rely on the representation that was given to them by their patient. The mere fact that it was denied repeatedly doesn't necessarily impart knowledge on them, because they know that the doctor may have decided not to prescribe the medication. They may have decided to prescribe a different medication. They may have submitted the form, and the insurer may have rejected it. But none of that knowledge is within the with this pharmacy, and I don't think that it would be appropriate for them necessarily to inquire. It would be inappropriate and a violation. It would intrude into the doctor-patient relationship for them to now say, well, doctor, you know, did you do this, and why didn't you do that, and what are you going to do instead of this? I mean, that's not the role of the responsibility of the pharmacist.
Let me ask you the question I asked your brother at the end. Patient here comes and says, I run out of my Topamax. Walgreens says, we have not received prior authorization from your doctor. I can give it to you, but it's going to cost you $399. I don't have $399. Do you then have a duty to say, I can give you 3 days as an emergency supply in order to keep you from suffering the symptoms that you may suffer if you are without the medication?
I can answer that. I can actually provide 2 answers to that. And first of all, I say whether or not they have an obligation. I think, first of all, it would go back to some of the other things that we've discussed, whether or not they should recognize as necessary, you know, whether or not they knew that without this medication that this could result in some serious, substantial harm, And for most situations, when a pharmacist receives a medication, they don't necessarily know why it's being prescribed. Medications that can be used for multiple purposes, the pharmacist might not even know the condition for which it's being treated. But in this particular case, keep in mind that what they're saying is that she went out with this medicine for weeks and weeks and weeks and weeks. So whether or not they gave her a 3-day supply in July or August, or even for September for that matter, wouldn't necessarily have changed what the ultimate income was, which was the unfortunate death of Yarushka Rivera. There isn't a requirement. Mass Health says that in that situation, we will pay for those. We will cover that 3-day supply, but there's not an obligation on the pharmacy to do it. That's Mass Health and maybe even some other insurers that say in this circumstance, normally we'll only pay if it's a valid prescription and it comports with our the type of coverage that we afford. As an exception, we'll allow you, the pharmacy, to give a 3-day supply, and then we'll reimburse for that. But that's the extent of the 3-day supply.
All right, thank you.
Thank you.